The dangers of changing your state's constitution. We're talking about Marsy's Law on today's AK Show. Marsy's Law is named after Marsy Nicholas, who was a young college student in California, and she was murdered by an ex-boyfriend in 1983. Her parents, very shortly after her murder, were confronted by the accused killer at a grocery store after they had visited her grave. And this is, of course, an emotional story that started a saga to change every constitution in the United States of America, as well as our U.S. Constitution, to protect victims' rights. The point was that the family had no idea that the killer had even been released. And in 1983, we didn't have very many victim rights statutes or protections in any constitutions. And of course, this is a law that came out of California, where we see a lot of things start and then spread across our nation. Victims' rights sounds like a good idea, and it can be. But like everything else, we need to have limits and boundaries on what we're protecting, how we're protecting it, and the specific wording and language that we're using when we do it. So why are we concerned about protecting victims' rights? Well, let's take a look at what is happening in Idaho right now. And keep in mind that similar things are happening or have happened across the country, raising the very same concerns that we're looking at this legislative session and in a couple prior sessions in the state of Idaho. Every state in this country already has legislation protecting victims' rights, and most states have constitutional protections protecting victims' rights. So we already have a statute here. Don't be fooled into thinking that we're not protecting victims' rights in the state of Idaho or anywhere else. We already have the notification processes. We have the right for people to come forward and ask for protection during a criminal proceeding. But the change that is being proposed is so strange and so suspect that you need to understand exactly what it is. So in the Idaho Constitution, currently, a crime victim is as defined by statute. So what does that mean? That means we look in our criminal code, where the crime victim's rights are spelled out in our statute, to see what a victim of crime is. A victim of crime in this statute is someone who has suffered some kind of harm as a result of a crime or juvenile offense. And the statute requires that in order to get the protection as a victim that we provide you in our Constitution, the accused person has to actually be charged with a crime. This session, our legislators so far are supporting, overwhelmingly supporting, removing the language in our Constitution that says that you have to be charged with a crime. So now, who qualifies as a crime victim could be anyone who can say that they have been somehow victimized, whether someone has been charged by a prosecutor or not. Why is this important? Well, because in order to be charged or to be arrested or to be convicted, you at a very minimum have to meet a standard called probable cause. Probable cause means that there's evidence that exists that you actually committed the crime. There's some kind of proof. And if there isn't enough evidence to show probable cause that you committed the crime, you don't get charged, and there is no crime victim. And right now, the way that this proposed amendment to our Constitution is written, that all goes away. So when you hear people saying this is a red flag law, this isn't a red flag law. Red flag laws are very specific laws, and I've gone over those in a couple of other videos. We'll put links up on this video so that you can watch them if you haven't, or review them. This is not a red flag law, but it has the possibility to simulate it, because it opens the door for anyone, whether someone has been charged or not, to say they're a victim of a crime and ask the judge for protection to keep them safe. The supporters of this proposed amendment claim that we have nothing to worry about, because they are also proposing language that states that nothing in this victim's rights protection supersedes our federally protected constitutional rights. Okay, Well, to date, we have states that are passing laws that allow family members to ask a judge to take guns away. And to date, that has not been held to be unconstitutional. So this language really doesn't help us. And there's another bit of strangeness in this proposed amendment, because also in the new definition of what constitutes a crime victim, they have put language in that says that a crime victim, and this is a quote, does not include the accused. If you've read my book or you've been in one of my classes, you know that one of my major points when I'm talking to you about the use of deadly force is to make it very clear to you that if you have had to act to defend your life or the life of a loved one, you are the victim. And I make that point by asking you, you're looking at the body in the pool of blood, the person that you just shot, who's the victim? And 99% of the time, people raise their hand and they say the person in the pool of blood is the victim. And that's exactly what this amendment says. It says if you use deadly force in defense of yourself or another person, and you are charged or not charged now with the new language, you're not the victim. The person that you used force against, who presumably was committing a crime against you or your family, is actually the victim. This is a horrible, horrible proposal to our state constitution. A lot has changed since 1983 when Marsy Nicholas was killed. And as I stated in the beginning, we already have protections for crime victims in our state and in every state in this country. So to muck about trying to change language in our state constitutions, not a good idea. We don't want to be like California. They have over 500 amendments to their constitution. Alabama has over 900. The average nationwide is 115 amendments to a state's constitution to date. We don't need this. And it is a strange and dangerous proposal to change the definition of who is a victim of a crime. Marsy's law is not only opposed by the Idaho Second Amendment Alliance, it's opposed by Gun Owners of America, it's even opposed by the ACLU. So don't be fooled into thinking that we need victims' rights. We have a robust system of victims' rights in our state and in every state in the country. If you ever attend a criminal court proceeding, you will hear the judge and prosecutor consistently talking back and forth in any hearing about whether a victim has been notified. Victims have the opportunity to come forward, to speak to the court, to make requests to the court. Most DAs have an office devoted to helping and notifying victims through the criminal justice system. The road to hell is paved with good intentions. And while Marsy's law may sound on the surface like a good idea, once you understand the history and you understand that this is coming out of 1983, and in Idaho we've changed our constitution in 1994 to include victims' rights. Every state in the country now includes rights for victims, either in their constitution or legislatively or both. Why are we trying to now include people as crime victims when nobody's been charged? And why are we specifically excluding people who may be charged when they use deadly force? It's up to you and me to make sure that this proposed amendment to the Constitution does not pass. I'm Alex A.K. Kincaid, and thank you for watching The AK Show. I'm Alex Kincaid, and thank you for watching The AK Show and 3F Words. We support a couple of charities. One is the Hidden Hollow Horse Rescue, where horses and veterans find solace. Donate and you will be sent a lovely prize, maybe a mug, maybe something else. And we are listing a link to this organization to bring veterans some peace and harmony out in the Idaho wilderness in our bio. We also have a link to the Alex Kincaid Law Scholarship Fund, where we support America's conservative youth in attending college. So thank you for your donations, thank you for watching, and as always, we welcome your comments and questions.